Adeze Obi was 41 years old when her husband of 9 years stood before a family court judge in Charlotte, North Carolina, and asked him to throw out the prenuptial agreement she had drafted herself, in its entirety, on the grounds that it was unconscionable and that she had failed to adequately disclose her assets at the time of signing. Her husband Marcus had arrived at that courtroom in a suit that cost more than her first car. He had an attorney named Richard from a firm downtown that specialized in high-net-worth divorce litigation, and Richard had a reputation for the kind of confident, methodical dismantling of protective agreements that made him expensive and usually effective. Marcus had been telling people for 3 months that the prenup was going to be gone by spring. Adeze drove a 2012 Camry with a parking sticker from a community hospital where she volunteered 2 Saturdays a month. She had worn the same 3 pairs of good earrings for 4 years. She packed her own lunch when she remembered and bought it from the deli on Trade Street when she did not. The attorneys in her building had worked beside her for 6 years without fully understanding the scope of what she managed. What Marcus had not understood in 9 years of marriage was that Adeze Obi had drafted the prenuptial agreement he was now asking a judge to dismiss, and that she had drafted it the way she drafted all significant instruments, which was with the careful, layered precision of a contract attorney who had spent 17 years identifying the clauses that other people missed. He had not read it carefully enough. She had been counting on that. The prenup contained a provision, on page 11, in the subsection governing business entities formed prior to the marriage, that Richard would not find until he was in the middle of his oral argument. The provision did not protect her assets from him. It protected his assets from the court, contingent on the prenup's continued validity. If the judge dismissed the prenup, that protection dissolved. Marcus had asked for the dismissal. What happened when the judge granted him exactly what he asked for was the most expensive lesson in contract law a man had learned in that courthouse in a considerable number of years. Before we jump into the story, comment where in the world you are watching from and subscribe, because tomorrow's story is one you need to hear. The morning of the hearing, Adeze was up before 5. She made coffee in the kitchen of the house in the Dilworth neighborhood of Charlotte that she had purchased 6 years into the marriage with funds from an account she had maintained in her own name since before the wedding. And she stood at the window that faced the back garden she had planted the first spring she owned the house, which was established now and required very little managing, which was what a well-designed system did when you gave it enough time and correct conditions. She was a contract attorney by profession, which meant she spent her working life in the architecture of obligation, building the structures that governed what people owed each other and what they did not, identifying the gaps between what agreements said and what their signatories believed they said, which were frequently not the same thing. She had a particular reputation among the attorneys who knew her work for the quality of what she called her subsurface clauses. Provisions embedded in the ordinary-looking language of an agreement that revealed their significance only when someone put weight on them from the wrong direction. She had been building subsurface clauses since her 2nd year of practice. She had been building them for herself since the year before she married Marcus. Her grandmother, a woman named Chidinma, who had immigrated from Nigeria with her husband in the early 1970s and raised 4 children in a row house in Greensboro while running a tailoring business out of the front room, had told Adeze when she was in law school that a woman who understood the language of contracts would never be held to terms she had not agreed to, and that the first contract a woman should understand completely was any agreement that governed what she owed to another person. She had said this in the specific, practical way she said most things, which was as though it were obvious, and she was simply making sure Adeze had not missed it. Adeze had not missed it. She had, in fact, built a career from it. She and Marcus had met at a professional reception in Charlotte 9 years before the hearing, a reception for a business association he belonged to, and which she had attended as the guest of a colleague. He was a commercial developer, broad and charming and specific in the way of men who had built things with their hands and expected to keep building them, and had not yet encountered a situation that required a different set of tools. He had found her at the edge of the room, where she usually stood at events like this, and asked what she did, and she had told him she was a contract attorney, and he had said that was interesting in the tone of a man who had meant it. They had talked for 2 hours about contracts and construction, and about the gap between what agreements promised and what they delivered, which was a subject they approached from different directions and found, to both their surprise, that they agreed about in all the fundamental ways. She had been thorough about him for the 8 months before she agreed to marry him. She had been thorough about everything she intended to commit to significantly. It was the same rigor she brought to major contract engagements, which was to say she did not sign until she had read every page. And she did not read every page, only once. The marriage had been correct for the first 4 years, which was the period in which Marcus was still building his development company toward a scale that required his full ambition, and during which Adese was a sufficient audience for that ambition, and a useful partner in the legal infrastructure of its growth. She had reviewed 6 contracts for his company in those 4 years, professionally, at full rate, billed through her firm, because she was a woman who did not confuse professional contribution with personal obligation and had structured their arrangement accordingly from the beginning. By the 5th year, the company was large enough to have its own in-house counsel, and Marcus had grown accustomed to that counsel and had stopped bringing his work to her, which she had found, without distress, that she did not miss. By the 7th year, he had developed the manner of a man who had concluded that the most valuable thing in the partnership was the one he brought to it, and he had adopted the habits of that conclusion gradually and without announcement. He stopped asking about her cases. He attended fewer of the things she invited him to. He held his phone in the tilted way that she recognized, from 17 years of reading behavior, as the posture of a person with a separate life being conducted in the same hand that held their shared one. She had known about Sandra for 6 months before she filed. She had used those 6 months the way she used all significant preparatory periods, quietly, without alerting the other party to the preparation, and with complete attention to the documentation. She had also spent them reviewing the prenuptial agreement clause by clause, which was a task she found professionally satisfying in the way that any well-built instrument was satisfying when you returned to it after years and found that it had held. She had called her own attorney, a woman named Josephine Akabe, who had practiced family law in Charlotte for 22 years and who had been Adese's referral for personal legal matters since they had met on a bar association committee 7 years prior. Josephine practiced from an office in uptown Charlotte that she owned outright, which Adese had taken as a useful signal when she first visited it, in the same way she took all the physical details of a professional space as information about the person who occupied it. The office was organized with the precision of someone who had learned long ago that a well-organized file was the difference between winning and losing a motion you should have won. And Josephine's files were organized impeccably. Josephine had reviewed the prenup in a single sitting, which took her 90 minutes, which was the right amount of time for 43 pages of substantive agreement if you were reading it correctly. She had sat quietly afterward for a moment, with the document open to page 11 and her reading glasses down on the end of her nose, and then she had looked at Adese and said, "You drafted this yourself?" Adese said she had. Josephine said, "Does he know that?" Adese said, "He knows I am a contract attorney." She said she was not certain he had thought carefully about what that meant for the document he had signed, without having his own counsel review the full 43 pages, which was the option that had been offered to him. and which his independent attorney had conducted with what Adaise would describe as adequate, but not exhaustive attention. Josephine had looked at page 11 for a moment longer. She said, "What do you want the outcome to be?" Adaise said she wanted Marcus to receive exactly what the court determined he was owed under a full review of the available information. She said the most efficient path to that outcome was to allow his attorney to make the argument he intended to make, which she had been anticipating for 4 months, and for which she had prepared accordingly. She said one more thing. She said, "I retained Gerald Pitt 3 months ago." Josephine had known Gerald Pitt for 11 years and had worked with him on 7 cases, and was not a woman who expressed surprise at professional information, but she set her pen down for a moment before picking it up again. She said, "How much did he find?" Adaise told her. Josephine wrote the number on the legal pad. She underlined it once, which was the kind of emphasis she used for numbers she intended to cite in open court. Gerald Pitt had been given 6 weeks and had needed 4. His forensic accounting summary was 11 pages, which was the length of his summaries when the evidence was significant but not complicated, because Gerald did not use length as a substitute for clarity. The undisclosed accounts appeared on page 3. He had traced them through 3 institutions and 2 holding vehicles to their source in compensation and investment returns that had been systematically separated from the joint filing. He had prepared the summary with the annotated precision that made his work usable by an attorney on first reading, which was one of the qualities that made him the accountant Josephine called when the stakes required someone who would not make her explain the numbers to the judge twice. Adaise had reviewed the summary when Gerald submitted it. She had read it the way she read all financial documents, which was looking for the gap between what it said and what it would be understood to mean by someone who did not read financial documents carefully. There was no gap. Gerald had closed every one. She had authorized Josephine to produce it at the appropriate moment, which she had specified would be after Richard had completed his opening argument and made his request, because she was a woman who waited for the weight to arrive before she showed the foundation she had built to hold it. The prenuptial agreement had been drafted by Adaise in the year before the wedding and reviewed by an independent attorney she had retained for Marcus's benefit, because she understood that the validity of the agreement depended on both parties having received independent legal counsel, and she was a woman who built agreements to be valid. The independent attorney had reviewed it and raised no material objections. Marcus had signed it 3 weeks before the wedding at a closing table in Josephine's office, with 2 witnesses and a notary. The agreement was 43 pages long. It disclosed Adaise's premarital assets with complete specificity, including the accounts she held, the property she owned, the professional practice she had built, and the ownership interest she held in a private investment vehicle called OB Capital Holdings ILC, which had been incorporated 4 months before the wedding. The LLC was described in the disclosure section as a premarital investment vehicle with anticipated future capitalization, which was accurate. In the 9 years of the marriage, OB Capital Holdings had grown from an entity with a modest initial capitalization to a holding company with 4 portfolio investments valued, at the time of the filing, at $94 million in aggregate. The prenup's premarital asset protection clause covered the LLC and all its derivative value. The agreement also contained, on page 11, a provision Adaise had drafted specifically, and which she had placed where she placed it, because she was a woman who understood where attorneys who were looking for weaknesses looked first and last, and not often in between. The provision stated that in the event the prenuptial agreement was challenged and dismissed by court order, all protections afforded to both parties under the agreement would dissolve simultaneously, including the provision that shielded the non-challenging party's separate property status from equitable distribution review, and that upon such dismissal the entirety of the marital estate would be subject to the court's standard equitable distribution analysis under North Carolina law. Marcus held, in his personal accounts, $2 million that he had accumulated during the marriage through investment returns and compensation that had not been disclosed on the most recent joint tax return. The prenup's existence had meant this asymmetry had not been relevant. Its dismissal would make it very relevant. Adize had known about the $3 million for 4 months. Gerald Pitt, a forensic accountant she had retained through Josephine's referral, had found it in 6 weeks and had documented it in a summary that was currently in Josephine's briefcase. The hearing was on a Thursday morning in March. The courtroom was clean and efficient, in the way of rooms designed for the management of difficult truths, with natural light from high windows and rows of wooden benches that filled with attorneys and their clients, and occasionally other attorneys who were there to watch. Josephine had told Adize that Richard's reputation in these proceedings drew observation because he was considered among the most effective prenup challengers in the practice area, and other attorneys liked to study his method. Several of them were in the gallery. Marcus arrived with Richard and a paralegal and the composed confidence of a man who had been told his position was strong. He sat at the respondent's table across the aisle from where Adize sat with Josephine and did not look at Adize directly, which was the approach he had adopted since the filing, which was also the approach he had adopted in the last 2 years of the marriage, which was to look past her toward the thing he had decided she was blocking. Richard opened his argument by establishing that the prenuptial agreement was unconscionable at the time of signing, citing the disparity between the disclosed value of the LLC at incorporation and its current value as evidence that Adize had materially misrepresented the asset's anticipated worth. He argued that no reasonable person, reviewing the disclosure as written, could have anticipated that the entity described as having modest initial capitalization would come to represent $94 million in holdings. Josephine did not interrupt. She had told Adize before the hearing that she would not interrupt Richard's opening argument, because the argument needed to be complete for the response to be complete, and because she had found over 22 years of practice that the most effective response to an argument was the one delivered after the other attorney had finished being wrong. Richard continued for 21 minutes. He cited 3 prior cases in which similar prenup challenges had succeeded. He cited the disclosure clause and the language she had used, and the gap between disclosed value and actual value. He concluded by asking the court to dismiss the prenuptial agreement in its entirety and to proceed with equitable distribution of the full marital estate under North Carolina's statutory guidelines. The judge, a woman named Honorable May Bryant, who had been on the family court bench for 14 years, and who had the particular patience of someone who had learned that the most consequential moments in her courtroom arrived quietly, looked at Josephine. Josephine stood. She said she would like to direct the court's attention to page 11 of the agreement, which she had already placed before the judge as part of the respondent's exhibits. She read the provision aloud. She read it completely and without abbreviation, because the language was precise, and precision was the point. The courtroom was very quiet. Richard looked at his copy of the agreement. He found page 11. He read the provision. He read it a second time. He set the document down with the careful evenness of an attorney managing his visible response to information that had arrived unexpectedly. Marcus looked at Richard. Richard did not look back. Josephine said, should the court grant dismissal as requested, North Carolina's equitable distribution statute governs the full marital estate, including all assets acquired during the marriage by both parties. She placed Gerald Pitt's forensic accounting summary before the court. She said there were financial developments on the petitioner's side of the ledger that had not been reflected in the joint filings, and that would become relevant to equitable distribution upon the prenup's dismissal. Gerald Pitt's summary was 11 pages. The undisclosed accounts were on page 3. Marcus's composure changed in the way composure changed when a person understood, in a single moment, the precise distance between what they had planned and what was actually happening. The change was not dramatic. It was the kind of shift that happened inside a face, in the muscles around the eyes and the set of the jaw, the kind that the people trained to read those shifts noticed immediately. The judge reviewed the provision. She reviewed Gerald Pitt's summary. She asked Richard if he wished to revise his request. Richard asked for a recess. They took 40 minutes. When they returned, Richard informed the court that the petitioner was withdrawing the motion to dismiss and requested that the parties be permitted to proceed directly to settlement negotiation. The judge granted the request. She looked at Richard with the expression of a judge who had seen many experienced attorneys leave a courtroom more educated than they had entered it. The settlement that emerged from the following 6 weeks was not the settlement Marcus had walked into that courthouse expecting. The prenup stood. OB Capital Holdings was confirmed as separate property. The marital liquid assets were divided equitably. The undisclosed accounts, now fully documented, were included in the marital estate calculation, with the adjustment that their non-disclosure warranted under the equitable distribution standard. Marcus's attorney negotiated the best available outcome from the position available to him, which was not a strong one, and which he had made weaker by the motion he had filed and then withdrawn. Adese walked out of the final settlement hearing on a Tuesday afternoon in April. She walked out the same way she walked into every significant room, which was with the same pace and the same posture and the same complete attention. She gave everything, because she did not change her behavior based on who was watching. She thanked Josephine on the steps. She drove herself home. She made tea in the kitchen she had purchased with funds from the account the prenup had protected. She sat at the table she had chosen for the quality of the light it received in the late afternoon. She thought about page 11 of a document she had drafted 9 years ago, and about the particular satisfaction of a provision that had never needed to be invoked until it did. 11 months later, Adese Obi lived in the Dilworth house that was hers, had always been hers, and now held a garden that was productive enough that she had begun giving its surplus to the neighbors on either side and to her colleague who asked for the tomatoes specifically. She had taken on a junior partner at her practice, a young woman named Priya, who had found her through a bar association conference and who asked the kind of questions that suggested she already knew how to think and only needed someone to think alongside. Adese had offered her the position 3 months after they met. OB Capital Holdings had made one new acquisition in the year since the settlement, a healthcare technology company that 2 of her portfolio advisors had identified and that she had reviewed and approved with the thoroughness she applied to all significant decisions, which was the thoroughness of a woman who had learned to read what agreements said and what they did not say, and what the gap between those 2 things was going to cost the person who had not noticed it. A man named Augustine, who was a civil engineer she had met through a client introduction and who had asked her to dinner twice before she had availability that was genuine rather than polite, had come to dinner at the Dilworth house twice in the preceding month and stayed both times to help with the dishes without being asked, which was a small thing and the kind of small thing she had learned to value at its correct weight. Marcus had settled his development company's pending project financing at a number lower than he had projected, according to a trade publication that covered commercial real estate in the Carolinas. Sandra had relocated to Atlanta. Adese heard these things from colleagues who mentioned them the way people mentioned resolved matters, and she noted them and moved on, because she was a woman whose attention went where it was producing returns. On a morning in March, 11 months after the settlement hearing, Adese sat at the kitchen table with her tea and the light coming in the way it came in that room in the early morning, low and direct, and she reviewed a draft agreement her junior partner had prepared for a client review. Priya had placed a provision on page 7 that Adise had suggested at their last meeting, and she had placed it exactly where Adise had indicated, in the language Adise had recommended. It was a subsurface clause. It would not reveal itself unless someone put weight on it from the wrong direction. She made 2 small notes in the margin. She thought of her grandmother Chidinma's voice, saying, "A woman who understands the language of contracts will never be held to terms she has not agreed to." She had agreed to exactly the terms she had written. She had been held to every one of them. So had Marcus. She turned the page and continued. The work was always in the next page. She had always known that. Her grandmother had known it too. In the front room of the Greensboro house, at the tailoring table, in the language of stitches that held under pressure. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.